Ministry of Justice, distinguished seniors and colleagues, and directors here present. Olamide Ibrahim is my name, and it is once again my privilege to welcome you to this edition of the Learn series, which promises to be very interesting. Today's Learn series features a topic that I consider to be of great importance and concern to us as State Council. We're looking at the topic, fundamental human rights and the ever-increasing jurisdiction of the Federal High Court. Of course, I call it a topic of great concern because of the challenges that we've had to face as State Council when we attend the Federal High Court in respect of matters bordering on fundamental human rights. It is disturbing that judicial authorities seem to take the view that parties are at liberty to choose which court to institute fundamental human rights, notwithstanding the parties. And so the question is, should this position still apply when it is the state government that is involved or an agency of the state government? I mean, these are things that we've had cause to contend with as State Council when we appear before the Federal High Court. Another issue is whether the Federal High Court can sit over affairs, but involving the state, thereby making itself as a body that is capable of playing supervisory roles over the affairs of the state. These are some of the issues that we would expect today's facilitator to look into as we go through the topic. The person that is going to be taking us through the subject today needs no elaborate introduction. We all know him. We know him so much. He's Dr. Babatunde Ajibade. The events that have been going on in the legal world in Nigeria today even point more to who he is in the profession. But the role he's playing today is that of a facilitator, and we're going to be enjoying his wealth of experience and knowledge, having earned his own as a senior advocate of Nigeria. So without much preambles, I would give the mic to Dr. Babatunde Ajibade, and I'm very sure he's going to do justice to the topic. Doctor, you have the floor, sir.
Thank you. Thank you very much, Mr. Ibrahim. The Honorable Attorney General, the Permanent Secretary, Solicitor General and Permanent Secretary, Ministry of Justice, Lagos State, directors present, and other senior members of the Ministry of Justice. I know that I sought permission for the Ogun State Ministry of Justice to join us on this platform. I don't know if there are any members of the Ministry of Justice in Ogun State on the platform, but if they're here, you're welcome as well. I thank you for affording me this opportunity to share some thoughts with you on what Mr. Ibrahim has rightly described as a very interesting topic. I will say straight away that it is only from Mr. Ibrahim's introduction that I understand for the first time the perspective that you had in mind when you put this topic forward. I was given 3 or 4 topics to choose from, and I immediately honed in on this one because it touches on one of my own pet concerns about the functioning, or should I say, non-functioning of aspects of our justice sector. But I did not appreciate that your concern is what Mr. Ibrahim has just expressed. Nonetheless, I will do my best to address even that concern. And this is definitely not going to be a lecture. I think it's going to be an exchange of ideas, because the problems in this space are problems that I think we all should be worried about, and we all should be thinking creatively about how to solve. My underlying belief is that we as legal practitioners owe it to ourselves and to our clients, whether our client is the government or whether our client is a private citizen, to ensure that the justice delivery process works as smoothly and as efficiently as possible. And I don't think there's anybody who practices in our courts who would say that that is the case today. And I think we really need to bend over backwards to try to address these problems creatively and holistically. Now, I've prepared some slides which I will now share. The slides are based on what my own pet peeve is, which I've actually had the privilege of sharing with the Ministry of Justice, Lagos State Ministry of Justice in the past. And it's of great concern that despite that, this is what, maybe 8, 9, maybe even 10 years ago, nothing has changed in that space. And this really is part of the concern. The fact that our laws don't seem to change because of matters of general concern. I mean, our constitution now has been altered 4 times. And if you look at those alterations primarily deal with issues that affect specific sectors, our politicians and some of our colleagues in practice who do electoral law. But I don't know that many of those amendments have dealt with things that are of general benefit. And as I would say when I come to my proposals, I think that the issues that we're grappling with here are issues that will require constitutional reform. And I'm hoping that we will all, as a body, focus on ensuring that those necessary constitutional reforms are put in place to make our system work a lot better. So this is my introductory slide, and it just shows the issues that I intend to run through. And I'll run through this before I now deal with the specific aspect of the problem that Mr. Ibrahim has now teed up for me. I look at the history of the Federal High Court, jurisdictional issues arising from this history as it relates to fundamental rights enforcement proceedings, fundamental problems with the allocation of jurisdiction amongst our superior courts of record, the inevitable overlaps between their jurisdictional limits, and then my proposals for constitutional reform, which, like I said, for me, the focus should be on achieving substantive justice. And I'm not sure that we're doing much of that under the current dispensation. So the Federal High Court, the Federal Revenue Court, as it was originally called, was established in 1973, as we all know. And it started out as a court of extremely limited jurisdiction. As its name implies, it was only established to deal with issues relating to the revenue of the federal government. At that time, I think we were still operating a much truer federalism than what we have now. I think part of the challenges we're facing in Nigeria now is that constitutionally, even though we describe ourselves as a federal Republic of Nigeria, in several respects, we're actually running a unitary system. Now the Federal High Court, and this creep started with the 1979 Constitution. And this was when the Federal Revenue Court was renamed the Federal High Court. And in that constitution, I believe it was in section 230, the jurisdiction of the Federal High Court was expanded beyond the initial remit when it was described as Federal Revenue Court. And as we know, it has been expanded, several times since. Now, right from 1979, the Federal High Court had a jurisdiction in relation to fundamental human rights enforcement proceedings, pursuant to fundamental human rights enforcement proceedings rules that were contained in the 1979 Constitution. And this jurisdiction has been retained even now in the 2009 rules made pursuant to the 1999 Constitution. Order 1, Rule 2 of the rules defines court to include both the Federal High Court and the State High Court. And it was held as far back as 2004 that this meant that both courts had concurrent jurisdiction in relation to matters relating to fundamental human rights enforcement. Now, the issues concerning the overlap in the jurisdiction of the federal and state high courts was not, as far as I'm aware, an issue when the decisions in Grace Jack and University of Makurdi was decided. The question then was really more whether you had a choice. And the complications in relation to the underlying subject matter jurisdiction of the courts came into play in the decision in Adetona versus Igele General Enterprises in 2011, which was followed in Iheme versus Chief of Defense Staff and in Abdullahi versus Komolafe. In those decisions, there was an attempt to limit the fundamental rights jurisdiction of the Federal High Court or the courts to the subject matter jurisdiction of those courts. The Supreme Court in more recent decisions, in FUT, Federal University of Technology, Mina, versus, sorry, I don't see the Technology and the EFCC RENILs have now again confirmed that fundamental human rights enforcement proceedings can be brought in any high court within whose jurisdiction a breach only followed in versus concern that the Ministry of Justice has at the back of my mind. Now that I know what your concern is, the position of the law now, as I understand it, is that the Supreme Court has affirmed that irrespective of the underlying subject matter jurisdiction of the courts, a fundamental human rights enforcement matter can be brought either in the State High Court or in the Federal High Court. And the reasoning, as I understand it, as expressed by Honorable Justice, I believe it was Justice Kekereekun, in just a second. Yes, in the EFCC versus IRENIL case, Justice Kekereekun held that it is quite evident that Section 46(1) of the 1999 Constitution as amended above refers to a high court of a state without any restriction. The violation of a citizen's fundamental right is viewed so seriously that the framers of the Constitution sought to ensure that no fetters are placed in the path of a citizen seeking to enforce his rights. In other words, the provision ensures that he has access to any high court as long as it is within the state in which the alleged infraction occurred. Indeed, it would negate the principle behind the guarantee of fundamental rights if citizens were to have any obstacle placed in the path of enforcing those rights. There is no ambiguity in the provisions of the Constitution or of the Fundamental Rights Enforcement Procedural Rules regarding which court has jurisdiction to entertain an application for the enforcement of fundamental rights. So this is the Supreme Court emphatically stating that once the matter is a fundamental rights enforcement matter, it can be brought before either a state high court or a federal high court. As I said, now that I understand the concern from the Ministry of Justice to be that this is being employed as a means of bringing matters before the federal high court, which would ordinarily not be within the purview of the federal high court. I think that this actually underscores what I will be discussing when I talk about the way in which I think the question of the jurisdiction of the federal and state high courts ought to have been addressed well before now. The Federal High Court was established in 1973. That is by conservative estimate, just under 50 years ago. And I think it's a matter of, I find it quite distressing that almost 50 years later, we're still having these tangos between courts that were established pursuant to the same constitution. Because as I said, the truth is we're not running a proper federal system. If we're running a proper federal system, this would be an even more fundamental problem. We're running a pseudo-federal system. These are courts established by the same constitution, and yet we have not been able to coordinate the operations of those courts to avoid the kind of concerns that the Ministry of Justice is expressing, and to avoid the kind of issues that our justice sector is suffering from as a result. And for me, my fundamental approach to this is that we must, as a justice sector, do a lot more to coordinate the activities of our courts with a view to delivering a result to society. The way in which I view this, and the way in which I view this when I had cause to address the Ministry of Justice several years ago concerning this question of jurisdiction between the state and federal high courts, was that we must situate this within the context of the fact that these are courts of coordinate jurisdiction. I mean, this is not a situation where you're talking about the jurisdiction of a magistrate court and the jurisdiction of a superior court, where the qualification of the judex, where the presumed capacity of the judex to resolve the dispute is in question. These are courts where qualification to be a federal high court judge or to be a state high court judge is exactly the same, 10 years post-call. Ultimately, the appointment procedure still goes through the same National Judicial Council. The disciplinary procedure for judges of both courts still goes through the same National Judicial Council. So for me, this is a situation in which there must be or should be much better coordination in the allocation of jurisdiction between these courts. There is no obvious attempt that I've seen to coordinate their jurisdiction. On the contrary, what I'm aware of, albeit through anecdotal evidence, is that the reason why over time the jurisdiction of the federal high court has consistently been increasing is because judges of the federal high court use their influence to lobby for enlargement of the jurisdiction of the court. And that's why it's gone from being a court with limited just the revenue of the federal government to get into banking and to various other matters. I definitely have, having said that, I definitely have sympathy for the concern expressed by the Supreme Court in the case just cited, that issues of fundamental human rights are of such importance that as little or as few bottlenecks should be put in the path of a citizen who is seeking relief, as few bottlenecks as possible. But I think all that should still be done within the context of coordination and resolution of the limits of either court. And the aspect of the problem that I have focused on historically, and which I will address a bit further now, before coming back to the concern of the MOJ, is really the delay. I think this dichotomy between the jurisdiction of the federal high court and the state high court, and we now have, of course, the National Industrial Court has joined the party, has been the incomprehensible damage it has wrought to the efficiency of our administration of justice and the perception of our profession and our entire justice sector. I mean, I've cited two cases here, Associated Discount House Limited versus Amalgamated Trustees Limited, CFAX versus MIGFO. These are all cases in which litigants have been put through the pain of litigating all the way to the Supreme Court and back about where to litigate. So the substantive, whatever it is their dispute was not touched at all. They went all the way to the Supreme Court arguing about, no, it should be in the state high court, it should be in the federal high court. And these are just two. There's so many cases like this in our court system today, clogging the system. And I think that it is bad for our system of justice. that we seem to be incapable, because this is a problem that is begging for a solution. The Federal Revenue Court, as I said, was established almost 50 years ago. That 50 years, almost 50 years later, we haven't been able to find a pragmatic and reasonable solution to this problem. I think is a matter of great shame. And it's something that I think that we must do something about, and that I would personally like to do something about. And I've made proposals to resolve this in the past. So one of those proposals for constitutional reform revolves around making it easier for these courts, all our superior courts of record, to transfer proceedings between themselves in appropriate cases. Whilst I say that we're not in a proper federal structure, we're running a pseudo federal structure, and whilst I recognize that that has disadvantages, clearly to me, one of the advantages it should have is that our federal courts and our state courts, being courts created by a central constitution, and being courts whose presiding officers are appointed by a central authority, one of the advantages I think that that should confer on us is the ability to coordinate the activities of these courts a lot better. And I suspect it was what was the motivation for the introduction of Section 22(3) of the Federal High Court Act, which was enacted some years back, conferring on the Federal High Court the power to transfer matters in which it felt that it did not have jurisdiction, if its jurisdiction was challenged, and if it agreed with that challenge. That section authorized it to transfer such matters to the State High Court. Subsequently, no, I think, sorry, this was Section 22(2). I think subsequently, 22(3), which conferred a similar power to transfer from the State High Court to the Federal High Court, was challenged. I'm not proud to say that I was the one who challenged it successfully in the Supreme Court, but I did, and the Supreme Court agreed with me that that provision was unconstitutional because the National Assembly, who is the one that enacted the Federal High Court Act, I successfully argued, did not have legislative jurisdiction to confer powers on the State High Court. But that decision, and the Fashaki Foods versus Shosonya case, in which I successfully argued this before the Supreme Court, is a 2006 decision. Now, what I would have expected, and what I urged on the Ministry of Justice in Lagos State, I've also had discussions around this with Oyo State, with Ogun State, is that it's a very simple thing. If the Supreme Court has accepted that the transfer provisions of the Federal High Court Act can only properly apply to the Federal High Court, and that if the state high courts want to have powers to transfer to the Federal High Court, then the state legislatures should enact the necessary provisions. Unfortunately, despite what I've said, this has not happened. I've advocated for it severally. I don't know that there's any state legislature that has taken that up. And it's something that I find quite puzzling, because that would at least be an intermediate remedy to part of the problem of matters going all the way to the Supreme Court, arguing about where to litigate. But then that is only one aspect of the problem, because of course, if you have, as is often the case, a litigant or counsel, and I'm a great advocate for not hoping that lawyers will not behave badly, but rather preventing them or limiting their ability to do so. I think for us to hope that lawyers with difficult cases will not seize every technical point that they can latch onto is wishful thinking. So I think the way forward is to eliminate those opportunities. And this is the problem with limiting it to just having transfer provisions, because even if you have transfer provisions, and I'll take us back to just to underscore the point, I'll take us to the decision in Associated Discount House. In Associated Discount House, if I remember the facts correctly, an action was brought in the Federal High Court, and the defendant challenged the jurisdiction of the court. And the Federal High Court transferred the case to the State High Court. The same party, when the matter got to the State High Court, also challenged the jurisdiction of the State High Court. And the matter went all the way to the Supreme Court. and late Justice, I forget his name now, of the Supreme Court was so frustrated, and he delivered a very interesting judgment, querying where that particular litigant wanted the matter to be heard. It was taken to the Federal High Court to challenge jurisdiction, was taken to the State High Court to challenge jurisdiction, and came all the way to the Supreme Court. So my point really in discussing the facts of that case is that we shouldn't rely on the good nature, just eliminate the opportunities for this kind of dilatory tactics. Because counsel who will take those kind of arguments are obviously counsel who are not interested in achieving substantive justice, but just want to delay. And if this is my proposed, what is my proposed solution? I think that the solution to this is the long-lasting remedy to this is constitutional amendment that enshrines the power of transfer in the Constitution, at least as it relates to all our superior courts of coordinate jurisdiction, and that makes the decisions of those courts when it comes to the transfer of cases matters that are not subject to appeal. Now, what that does, in my view, is that it retains the jurisprudence, because I think what might be part of the reluctance to change tack is that we've developed quite a significant amount of jurisprudence, all the way back to Jamal versus Steel Engineering, the Savannah Bank cases, all the interesting cases in the late 70s and 80s concerning the limits of the jurisdiction of the federal as against the state high court. I'm not advocating that jurisprudence should be thrown away, but I think that by now, given the fact that we have not been able to resolve the matter of the limits of the jurisdiction of the federal high court and the limits of the jurisdiction of the state high court with any finality, and I think it is impossible to arrive at any finality on this, because as we all know, as those of us who have argued these issues know, there will always be cases that are borderline. There will always be cases in which it is arguable that the case should be in the federal high court or should be in the state high court. And I think that we should try to eliminate a situation where litigants are suffering whilst lawyers are having these fine arguments about section 251D, subsection I, no, this is not the subject matter, or it is only the part of the claim that is in this court, the other part is in that court. I mean, so the litigant should split its case and go into half of the case should go to one court and half of the case to another court. I mean, it's a ridiculous system. And I think that laws are made for people. People are not made for laws. So if that is the problem we have, then I think that we should be creative in solving it. And the creative way to solve it, in my view, is to enshrine the transfer provisions in the Constitution and say that once, especially in a situation where the qualifications of the judex in this court is the same, these judges must be deemed to have the same capacity to resolve issues. Once a judge is confronted with an argument as to whether his or her court is the appropriate court with jurisdiction to hear a matter, if the judge accedes to that argument and exercises the power of transfer, that should be the end of the matter. If the judge declines and says, no, I believe that this matter is properly before my court, that should be the end of the matter. I don't think that we should persist in this litigating about where to litigate, because it delivers no justice to the litigants. That for me is the way we should proceed with this. And it brings to mind, what I say about us not having a culture of coordination. It brings to mind a discussion I had several years ago when I was still chairman of the Capital Market Solicitors Association with Professor Odita. Because as you may know, Professor Odita QCSA and practices both here and in the UK. And he delivered a paper to the Capital Market Solicitors Association then about when the office of the Financial Ombudsman was created in the UK. And that when it was noticed that there were potential overlaps between the jurisdiction of this Financial Ombudsman and the High Court, that I think it was the Lord Chancellor, called a meeting and they sat down and agreed on how to resolve those potential overlaps. In other words, it shouldn't be a matter for contestation between the two courts. No, this is my, already our courts complain that they're overworked. So one would assume that there shouldn't be any eagerness to take on any more work than they already have. So personally, I think that this is a matter where the justice sector ought to sit down between the CJN, the heads of court, both the federal courts and the state courts, and the attorneys general should sit down and look at this issue, propose these constitutional amendments, and agree on exactly how they would work. Now, it is in this context that I think that I can address what I now, as I said, understand to be the concern of the MOJ. If that kind of discussion is had between the judiciary, the heads of the judiciary, both federal and state, and between the attorneys general who represent the interests of the states, as well as the federal attorney general who represents the interests of the federal government, agreed, which will then regulate the power of transfer, such that if a matter is taken to the federal high court, in which under the guise of enforcing fundamental human rights, a matter that ordinarily ought to be within the purview of the state high court is brought to the federal high court, then the federal high court will immediately, upon proper application brought by an officer of the state, transfer the matter to the state high court. And such an order of transfer, as I've suggested, will then not be a matter that is appealable. Those are the kind of, in my view, progressive solutions that we should be looking for to solve this problem, so that it is not a matter of, oh, the state government or the state law officers feel that the federal high court is encroaching and that there is a competition. It should be a matter for collaboration, for discussion, and for resolution at the highest levels. And once those resolutions are reached and the proper directives are passed down, either by way of practice directions, etc., that will be the end of the matter. So that for me is like I said, I didn't have the background of what the concern of the MOJ was, but even at that, I think that the solutions that I've proposed for what was my own concern, which is the delays that are caused by this jurisdictional contest, I think that solution also potentially can address the concerns that the MOJ has expressed. So I thank you for, I did say that I would not use up to an hour. I thank you for listening to me. I thank you for giving me the opportunity to share my thoughts with you on this. And I'm now happy to take questions, debate, suggestions, disagreement, vehement disagreement if necessary. Thank you. Thank you very much.
Thank you very much, sir. I must say that you're indeed a genius, sir, because I know it's one thing to prepare for certain questions. It's another thing to be able to address questions unprepared for. So I appreciate you greatly for that, because in my opinion, even though you weren't given the background as to where we were coming from and what we were expecting from you today, I believe you've been able to touch on the issues as though you knew about them beforehand. Thank you very much, sir. Okay,
My pleasure. Thanks.
Yeah, thank you, sir. So can we have questions at this point? If anyone wants to ask question, I would encourage that you drop it in the chat box. Otherwise, if you want to have an intervention by speaking, I could enable your mic for you to do so. But let's have contributions, please. Contributions. Doctor is waiting for us to contribute.
There's a Nokia 2 that has a hand up. I don't know who Nokia 2 is though. I think somebody wants to say something. Nokia 2.
Okay, please. Okay. HAG wants to. Honorable Attorney General.
Okay.
Okay, sir.
Yeah. So I listened with rapt attention to the presentation by Dr. Ajibade SAN. His brilliant presentation did not take me by surprise, knowing the stuff that is made of. Dr. Ajibade, in particular, has championed an annual lecture series hosted by his firm, which I believe for almost over 10 years now, they've been dedicated to getting speakers to come and discuss various topics in the administration of justice. It's a pleasure to have you to come and share your thoughts with us, and very illuminating thoughts. I noted down the areas where you said the office of the Attorney Generals might need to take some action. I will definitely contact you to explore those areas, because indeed it's very sad for our jurisdiction that the biggest thing going on in our space is this needless battle over which court should entertain the subject matter or not. And like you rightly said, to the best of my knowledge, nothing deliberately is being done to resolve this festering sore, which has been with us over the years. And I think it's a shame on all of us not to be able to get rid of this nuisance, because that is what it really is, so that to enable people who have disputes to allow their disputes really be resolved by the courts. The way the system is being run right now, a party who doesn't have a defense need not even bother to prepare a statement of defense. All it needs to do is to raise issue of jurisdiction and then decide to take it all the way to the Supreme Court. We all know right now that civil appeals are a graveyard in our jurisdiction. So it's most likely that once that journey of jurisdiction is embarked upon, there will be no end, probably in the lifetime of the disputants and probably even the counsel. So your thoughts are very, very much welcome and appreciated. And we would look to see from our end what we can do to bring this to an end. Thank you very much for taking out time to be with us. I hope my other colleagues who have listened to this would engage you with questions. Those are just my own comments.
Thank you, HAG. Thank you very much.
Thank you, sir. Honorable Attorney General. So we have one question here from Olanrewaju Adebayo. It says, in view of the pronouncements of Justice Kekere as cited and discussed, what then is the essence of the transfer provision in respect of fundamental human rights matters before the Federal High Court or even the State High Court, as the case may be?
Yes. So Mr. Adebayo, the transfer provisions in the Federal High Court Act and the transfer provisions that I am advocating is not in relation to fundamental human rights matters. Those transfer provisions are general transfer provisions. So to the extent that the Supreme Court's decision, which I cited, says that where it's a fundamental human rights matter, you can go to either court. I agree with you that the transfer provisions as currently contained in the Federal High Court Act would not make much of a difference. But note that in the context, now that I understand the concern of the MOJ, that matters that ordinarily ought to be within the purview of the state courts are being brought before the Federal High Court under the guise of, by couching them as fundamental rights enforcement matters. And I think that that is a matter that can be resolved by fine-tuning the transfer provisions and coordinating the activities of the courts and getting the justices, both of the Federal High Court and the State High Court, to understand the concern of the states so that if such matters are brought before the Federal High Court, either inadvertently or mischievously, then the appropriate application can be brought to have them transferred to the State High Court. And if that discussion takes place, then the Federal High Court judge should have no problem transferring the matter accordingly. That is my thinking.
Thank you, sir. So, we have another one here from Dr. Babajide Martins. He says, most suspects who have cases to answer in criminal courts often go to Federal High Courts to forestall the investigation by disguising their rights are about to be infringed. Typical scenario is where offenses are committed in the course of claiming rights of ownership to land. So, there have been discussions about what kind of right to land should be couched as fundamental human rights. Of course, we know that the Constitution provides for rights that your right to land cannot be acquired compulsorily by government without taking certain steps. But of course, we know that certain persons go to the Federal High Court and then in matters not even relating to acquisition or not relating to fundamental human rights at all, they tend to frame it in such a way as to deceive the court into believing that it's a fundamental human right, and then they want the court to address it. So, he just cited us as an example, but I think his question is majorly about suspects who have cases to answer in criminal court, and then they go to Federal High Court to forestall investigation.
Well, I can read Mr. Dr. Martins. I can read his question, so I'll go ahead and answer whilst we wait for Mr. Ibrahim to come back on. Dr. Martins, I think you're raising very, very important points, and points that, like I said, I think ought to exercise and engage all of us. I think, maybe this is one of the reasons why these areas interest me so much. My PhD was in private international law, and I specifically looked at questions as to the enforcement of judgments within states, between states in a federation, and how the common law principles relating to the enforcement of judgment have been adapted in various common law federations to their federal structures. And it's interesting to see how various, the United States, Canada, Australia, Nigeria, and even to an extent, the United Kingdom, because even though we hardly realize it, the United Kingdom is itself a federation in a sense, because you have Scotland, you have Wales, England and Wales, you have Ireland, and they have their arrangements in which they manage the conflict of laws within the United Kingdom. What we haven't done, I think, in our constitutional setup is to dedicate sufficient attention to these underlying issues. For example, if just like you said, if there's land within a state and the state seizes the land without paying compensation or without going through the appropriate legal steps for seizing that land, And if there is a perception that the judiciary within the state is beholden to the state, and the person whose land, or the person who claims that the land was improperly seized from him or her, is not an indigene of that state, quite clearly, there is a plausible argument for saying that the arbiter in such a dispute should actually not be the judiciary of that state, that it should be a federal judge. Now, that is what in the US, and that's why, because the United States, their own federalism is a lot of, naturally, I guess, better, more advanced than ours. That is what they call diversity jurisdiction. So in the United States, the federal court system and the state court system is not just written into the Constitution. It's not just based on limits of oh, we want this subject matter. Okay, mining is federal. Contract is state. This is federal. No. One of the most critical elements of federal court jurisdiction in the US is what is called diversity jurisdiction. Once you have a dispute that touches, that is not exclusive or domestic to a state, then it has to go to federal court. So if it's between the government of one state and a citizen from another state, or it's between governments of two states, or it's between citizens in two different states, it activates the diversity jurisdiction and goes to federal court. Now, that is what we don't have here. And the questions you've raised, except we start looking at improving what word would I use now? Improving the sophistication of our federal system, these tensions will persist. And this is what I have in mind when I say that these are matters that should be matters of coordination. You cannot allow the court system to deal with this, because to an extent, they're not just judicial issues, some of them are political issues as well. So it's not something that you can resolve just by way of arguments before the judge, because they will raise political tensions. I mean, like I said, now that I understand what the concern of the MOJ is, you can see that potentially it's not so much about the legal provisions or about fundamental human rights enforcement rules or jurisdiction. It's about the perception that the federal authorities are taking over what ought to be state matters surreptitiously. Now, I don't think that is something that we should attempt to resolve by way of judicial decision. I think that requires a political solution, and where necessary, legislative amendment, and where necessary, collaboration and coordination between the federal judicature and the state judicature. And we haven't done that yet, and we must do that. These are serious discussions that have to be had in order to make sure that our system works properly. So I don't know that I've answered your question, but basically what I'm saying is that the answer to the question is not one that anybody can give. It is a solution that we all have to look for, and it will require significant conversations and negotiations going forward.
I completely agree with you, sir. And I think Doctor will share the same view as well, because it's absolutely the right way to go in dealing with this kind of issue. I just sent, okay, so he has just responded that thanking you for your view, sir. So I just sent a message to Nokia 2, and I don't think he wants to, he has any intervention. Okay.
Maybe he's just waving.
Probably. Okay. Yeah. There seems to be no other question at this point. Okay. So are there other things you would like to share with us? While we
yes,
round
now
up?
that I have, yes. Well, now that I have, just as a closing statement, I truly believe that we are all invested in this system. I was saying to somebody yesterday who was complaining about the courts, about our profession, and I said to him, well, for me, it's too late to go and learn carpentry, because if I had started carpentry 31 years ago, by now, I'd be making some very good chairs. I'm not going to go and start that now. This is the only work I know. So, and nobody is going to fix it for us.
Mhm.
We have to fix it ourselves. So I think we just, at the risk of sounding like a bad record, as the Honorable AG has said, we've been running these programs at our firm, SP Ajibade & Co, since 2008. By God's grace, we do it this year. It will be the 13th in the series. We've invested time and resources in delving into the problems of the justice sector just because of that reason, because we're passionate about this profession. And I know that this profession potentially can and ought to be playing such a big role in ensuring that our society is moving in the direction that we would like it to move in. So I'm prepared to do everything I can. I just urge everybody else, because, complaining is so easy. I think, we all know what the problems are. So rehashing the problems really doesn't get us anywhere. What we all need to do is to start thinking creatively about solutions and also thinking about what role we can play in ensuring that those solutions are implemented. So I thank you very much for the opportunity once again. And I look forward to being invited once more. This is my second appearance. I look forward to it.
Thank you very much, sir. I was just going to ask if you were going to oblige us. Should we come back to you? And I'm happy to.
Most definitely.
Oh, thank you very much, sir. Sorry, sir. Another question just came in now. Is it okay for us to take it, sir? Oh, okay. Thank you, sir. He says, how do you see this, sir? From the same Olanrewaju Adebayo. So a person is remanded in custody for a bit too long. He approaches the State High Court for Fundamental Human Rights Enforcement, but he is turned down. He now goes to the Federal High Court and gets a favorable judgment, which supersedes the other.
Yes, no. Well, Mr. Adebayo, that for me is patent abuse of process. So I mean, if you went to the State High Court and the State High Court declined, if the State High Court declined jurisdiction on the basis that this is a matter that should properly go to the Federal High Court, then of course. But then if he's forum shopping, hopping from one court and looking at this court didn't grant, okay, let me go to another one. That is an abuse of process, and I don't think that is appropriate. I mean, once the court has decided a matter, I mean, that should be the end of it.
Thank you, sir.
So that would be my view on that.
Thank you, sir. And then the Federal High Court gave a judgment in respect of compulsory acquisition, and so the person who went to the Federal High Court went, disguising it as fundamental human rights and says that the right of the owners of the right was infringed upon while taking over the property. And then should that even be taken? My question is, should that kind of issue be taken as a fundamental human right, considering the fact that it is likely to be contentious? Because the issue of service of notices, I mean, fulfilling the condition precedents to acquisition are things that I believe would require proof. So under what circumstance should the issue of compulsory acquisition of property be taken as a fundamental human rights matter? I'm sorry that this is opening up after we were almost rounding up. But
no, it's not a problem.
Yes.
Well, it's just like the question, when I was talking about the jurisdiction even of the states and federal high courts. Let's park fundamental rights proceedings aside for the time being. Yes. I don't think that there's no level of precision that you can get. Well, let me not say there's no level of precision. There will always be cases in which it is arguable. And which is why I talk about, my solution being, look, we need to negotiate these things. We need to rely on the good faith and knowledge and skills of the judicial officers. Because at the end of the day, I'll give you another example, which the very last, I mean, now that you say we're actually opening up things, the last in the series of our annual business luncheons, which was held in November last year, was on the question of the appropriate forum for the resolution of civil disputes, the courts or the law enforcement agencies. Because as you and I know, many a days now, somebody owes a bank money, the banks would rather go to the EFCC or to the police than to go to court, than to instruct a lawyer and go to court. And the question then at that business luncheon was, and we had bank company secretaries trying to justify what they do, saying that yes, but if the customer he diverted funds, that he borrowed money, he didn't use the money for the purpose for which it was borrowed, it was diversion, therefore they were entitled to go to the police rather than to go to civil court. You know, it's a plausible argument, but you can see that the purpose of deciding to go to one place rather than the other was not because they felt that this was a criminal matter, it was because they felt that this was where they could get more effective results. So it's the same kind of thing. So just like in your example, where you know there's an allegation that land has been acquired without going through the proper process, yes, you could say that it's a civil matter, but then if the litigant feels that he or she is likely to get either quicker or more effective justice in the other court, then you can frame your claim in such a way that it gives you access to that other court. There's no way in which we can ever ensure that these issues will not arise. There's no way in which you can allocate jurisdiction between different courts that there will not be overlaps or opportunities for this kind of, what would be the appropriate word now, for this kind of games to be played. So we must rely on the good faith, the sagacity, the knowledge of our judicial officers to do the right thing, keeping in mind that they also should have an interest in ensuring that the system works efficiently. And in addition, we also need to keep an eye on the importance of ensuring that our disciplinary process in the profession is up and doing. Because, you know, given the example that the question that was just asked, you go to one court, you ask for an order, it is refused, and then you go to another court and ask for the same order. Now, except you disclosed in the second court that you had actually applied for the same order in a previous court and had been refused, as far as I'm concerned, that's misconduct. You know, it's not just about being clever. That is misconduct on the part of the legal practitioner, because we're expected to act in good faith. We're expected to be straightforward and honest with the courts. We're not expected to be playing games. But then a lot of that is going on in our system because the disciplinary system is not functioning. Lawyers are getting away with murder. So these are some of the things that we need to fix to make the system work. Because, you know, if a few lawyers are sanctioned for those kind of games, then it will reduce the chances that they will continue doing that. So it's a complex problem that has different parts, and we have to fix all the parts simultaneously. At least we need to be working on all the parts simultaneously to get the system to work properly.
Thank you, sir. So we're certainly not living as early as we had hoped, because it appears questions are now coming.
Everybody has woken up.
Yes, sir. So the doctor says right to compensation or compulsory acquisition is a fundamental human right guaranteed under Section 44 of the Constitution. I think that was just a comment. And then this one from Institute says, this is late. Thank you, doctor. We appreciate your proposal for the heads of court to discuss. It seems to me, though, that jurisdictional conflicts under the 1999 Constitution of Nigeria are the question of interpretation and application issues. They seem to be twofold. Whether the Federal High Court has jurisdiction in all cases involving the federal government or any of its agencies, irrespective of the subject matter of the case, or whether the jurisdiction conferred on the Federal High Court is exclusive to the court or is concurrently shared with other high courts. Thank you for the proposal, sir. What are your views on this?
I mean, no, my views on this are, they don't change. Indeed, my good friend Tunde Fagbolu wrote, because we've been discussing, I discussed my proposals with him, and he published something in This Day, I think last week, either This Day Law last Tuesday or the week before, in which he took that proposal and put a twist to it, which might address this point. And the twist he took to it, which again ties in somewhat with what I just said a few minutes ago, was that in the egregious cases where a judge takes on a matter whose subject matter is clearly by no stretch of the imagination within the jurisdiction of his or her court. Because, you know, like I said, there are borderline cases. But say, for example, a federal high court judge, because he knows the petitioner, now decides to preside over a divorce matter. You know, there's no how do you, you know, there's no stretch of the imagination by which the federal high court can say that, you know, it has even colorable jurisdiction over divorce, over matrimonial causes. So that then should be a disciplinary matter, both for the judge and for the lawyer who brought the matter. At least that is the twist Tunde has put on, Tunde Fagbonlu put on my proposals for transfer without a right of appeal. So the concept of transfer without a right of appeal is that in those cases in which it is borderline, in which it is arguable, and one of them is, you know, like the one Doc has said, as he's pointed out, taking somebody's land without compensation it is arguably a civil claim. So you could go to the state high court and just sue for your land. You don't have to bring it as a fundamental rights action. But then if you feel that you prefer to go to the federal high court, and if ordinarily land would not fall within the jurisdiction of the federal high court, then you couch it as a fundamental rights claim. In either case, I don't think that one could successfully argue that either the state high court or the federal high court would be wrong to assume jurisdiction in that matter, because it is arguably within the jurisdiction of either court. So the transfer provisions are to address those kind of situations where if the court decides to retain jurisdiction, it arguably has a right to do so. If it decides to transfer the case, it is also within its rights to do so. Rather than having those kind of cases going all the way to the Supreme Court and spending 10 years litigating about, no, it should have been Justice A in the state high court and not Justice B in the federal high court. But in those clear-cut instances where there is no justification at all under the statutes for a matter to come before a particular court, one must expect, and that's why I say again, we must fall back on the good faith and the quality of our judicial personnel, that the judge will see that there's really no justification for this matter to be in my court at all in the first instance. So I mean, going to Mr. Shodi's question, there are certain cases involving federal government agencies that, you know, I don't have any of the authorities at the tip of my fingers, but there are cases in which it could be argued that, well, look, what was in issue here really was a contract. It was a simple contract. What does it matter whether a federal government agency happened, you know, to be a party? Even sometimes federal government agencies are joined to these actions as nominal parties just to bring the matter into the federal high court. If you look at the main parties, the main protagonists, you find out that they're actually not government agencies. So we need, again, to depend on the sagacity of our judicial officers and on the good faith of our practitioners that matters will be dealt with, taken to the appropriate courts, and that where they're taken to the inappropriate courts, that the judges will see through the shenanigans if an objection is raised. Because, you know, of course, and goes back to what I said in my slide, and which for me is actually the most important issue. And again, when I raised this in the context of addressing the Oyo State Ministry of Justice in relation to the administration of civil justice bill, we need to change our orientation. I think too often in our system now, it's as though counsel and even the judges, it's almost like, with the greatest respect, almost like a game. But I don't think it's a game. You know, for litigants whose either liberty, their livelihood, maybe everything they've ever worked for in their life is at risk, you know, having issues dealt with on the basis of these fine technical points doesn't really address their concern for substantive justice. You know, when you look at decisions like Okafor and Nweke, that it was signed by Jibola and Co. rather than by Mr. Jibola. and somebody's case, somebody's entire livelihood is thrown out because of that, after 15 years, may claim is now statute bad. I mean, it just makes a travesty of our system of justice. And these are fundamental issues that we need to address. And this is why we need to find solutions that will enable us to deliver substantive justice to litigants, not find technical points about, oh, you know, it was this court or that court that ought to have heard the matter. Because personally, I believe that most litigants, if given the choice, would rather have a decision that tells them you were right and he was wrong, than a decision that says, well, you won and he lost. Because you won and he lost on a technical point actually doesn't give you the same kind of satisfaction, in my view, as you would get, the same kind of vindication you will get when it is established that you were in the right and the other side was in the wrong. So maybe I'm waxing a bit philosophical, but that is the way I see it. That is what I think that our system should be aiming to deliver. Substantive justice and not the technical justice that comes out of our courts too often these days.
Well, thank you, sir. Now, talking about finding solutions. Now, the next question even seems to be taking the solutions beyond political and legislative intervention. So the person says, Learned Silk, that's Ajibade Odutola. Learned Silk, from my experience with civil matters, the claimants usually go to the Federal High Court for land matters, wrapped as fundamental human rights matter. The Federal High Court, in my case, asked parties to address the court on the issue of jurisdiction, and after hearing, transfer the matter to the State High Court. However, till date, after several visits to the Federal High Court, the matter is yet to be transferred since 2017. What do we do, sir?
Yeah, that is terrible. I mean, you know, well, again, this now takes me, we're not going to leave here. No, it's true, because you're touching on my pressure points. This takes me back to another of our business launches, I think 3 or 4 years ago. And that was on administration of the courts and the administration of justice and the need to draw a distinction. And that is, for me, it's actually a manifesto point. We cannot fix our justice sector under the current structures because the judiciary is not capable of administering itself properly. I think that our brothers and sisters in the judiciary should focus on administering justice, which is delivering judgments, listening to witnesses, considering arguments, and writing their judgments. But the administration of the courts really needs to be handled by people who have administrative training, management skills, and has to be properly funded. Because this problem that Mr. Well, I don't know if it's Mr. or Miss, but that Ajibade Odutola has just Mr. Odutola just raised, it's just a simple problem of management. How can you have an order of transfer since 2017, and we're in 2020, the file is yet to reach the State High Court? It beggars belief. You know, this is something that should be almost automatic within a couple of weeks at the most. That file should have been in the State High Court. So I think this is just a failure of administration. And until we get our judges to accept that they don't have the capacity to administer the courts, and let them focus on the administration of justice, and then we get people with the proper skills in to administer the courts, this won't change. When we had that business luncheon, the guest speaker was Mr. Fola Atowori, who used to be Solicitor General in India. And this is something that he had done research on. And it was clear in his mind that he compared jurisdictions. He said Nigeria and Kenya, who have similar structures, where the judges insist on not only administering justice, but on administering the courts, they exhibit the same levels of inefficiency, such as what has just been described. Whereas places like South Africa, the US, and the UK, where there's a clear distinction between the administration of justice and the administration of the courts, have much more efficient systems. Because the people administering the courts, they may not even be legal personnel. They may be business managers, they may be accountants, but their focus is on efficient administration. So I think that is the direction we need to be moving towards to resolve problems such as this. And of course, greater use of technology. Because ordinarily, those files should have been transferred through WeTransfer or Dropbox or something. I mean, so, and it won't take 3 years to send something through a computer.
That's very correct, and I agree completely with you. And in fact, even extending this a bit further is also the issue of the people who work in our courts. You know, majority of them are not even trained to do so. What I mean by trained, in Nigeria presently, I'm not aware of any educational training or degree, you know, that people who are meant to be working in courts or even with law firms go through. So it's just a question of somebody gets, you know, employed and the person is trained on the job. So, but what about having the appropriate values for what they do? Because I think the reason why we call ourselves lawyers is certainly because of the training we've gone through, you know, from the university to the law school, and then we're out with appropriate values for the legal system. But the people
Yeah.
that are picked off the streets and they're just trained, and then you have them do things that would be determining the future of, of
No, I agree with you entirely, Laude, but, you know, point of information,
yes.
and again, it's something that I'm trying to push.
Yes.
Honorable Justice Shola Williams retired. She took early retirement from the Lagos State High Court. She has established an Institute of Paralegal Studies. Now, I've spoken with her, and I'm going to continue to put pressure on her, because the Institute of Paralegal Studies she has established is, for the moment, focused just on paralegals for law firms. But I've taken her up on this exact point you just made, which is that I don't think that she's doing the justice sector a favor by not expanding that institute to train the support personnel in the courts. Because I agree with you that that is one of the great problems. Many a times you go to court and, you know, it's clear that even the judge, I mean, a lot of our judges are not ready to work hard, but even those who are ready to work hard, they're frustrated by, oh, the process is not in the file.
Yes.
Oh, they can't even find the file. You know, the support staff is just completely, they're all over the place. So like you say, I agree with you entirely. They need to be trained. We need to focus on providing them with proper training. And that also needs to be resourced, because, you know, the training is not going to drop from the sky. So even if you have to take people, you know, either they're just higher degree, I mean, school cert holders, but let them go through proper training that tells them exactly, shows them exactly what is expected of them, and make sure that they come out and give them a certificate that says that you're now a certified, you know, court clerk or court registrar with the necessary tool. You've been given the necessary skills to be able to deliver that service efficiently. These are some of the things that I think that a proper court administration would put in place. You know, would partner with someone like retired Justice Williams, and make sure that that institute is properly funded, and that even the current crop of support staff in our courts are made to go through that institute to be retrained. I mean, we're not talking about virtual hearings. How are virtual hearings going to work when you have court staff who are not computer literate? I mean, it's just not going to work. So we need to start realistically, and it then goes to the issue of how we fund our judiciary. Because, you know, the buzzword virtual hearing, yes, okay, you need to buy the equipment, you need to train people who will use the equipment. Where is there an allocation for that in our federal and state budgets? So there's a lot of work that we need to do to fix the problems in the justice sector. And like I said, there's no point just complaining about the problems. Let's identify the solutions and start making noise about implementing those solutions.
Thank you, sir. I mean, this is certainly an ongoing discussion, and I would encourage us to all play our part. This is where we'll be ending the Lens series. Doctor, I want to say a very big thank you to you, sir, for coming.
Not at all. It's my pleasure.
Yes.
I've enjoyed it thoroughly.
Yes, same here, sir. I mean, I can see some people even clapping. If this wasn't virtual, I'm sure there would have been a very loud round of applause at this time. So let's imagine that we can hear the round of applause. Thank you very much, sir. We hope to see you. We hope to have you again sometime soon. So this is going to be the end of the Lens series for today. Thank you all for coming.
Thanks.
Bye. Bye, sir.
Bye-bye.
Bye.